Just so it's crystal clear, I'm a prosecutor with the Office of Military Commissions, full-time on the prosecution side. I have experience as a criminal defense attorney. I began my legal career as a Navy JAG officer where I defended sailors and Marines accused of violating the Uniform Code of Military Justice. I've been a state prosecutor, and I've been a federal prosecutor. And this is my most recent incarnation as a prosecutor. But I'm really here to answer your commissions one-on-one type of questions. Spencer.
There's no manual for the military commissions yet released. How do you expect that will influence or impact the proceedings, particularly, the Cotter hearing or anything else going forward?
Question in the back for those who may not have heard it. There are no rules that govern the military commissions. How do I expect that to impact? We expect the impact to be negligible right now because there is a statutory basis in the Military Commissions Act of 2009 that gives both the prosecution and defense enough to move forward. That being said, both sides do expect there to be rules signed very, very soon. Yes, ma'am.
In the suppression hearing where there's an issue of coercion, does the defense have to show that something is coerced in order to get it thrown out, or does the prosecution have to show that it's clean to get it admitted?
Right. The question is, who has the burden of proof in a suppression hearing? And it depends on who moved for the suppression of the evidence. In this case, the defense moved. It's their burden by a preponderance of the evidence. And for non-lawyers, preponderance is the lowest amount of evidence. It's evidence that's a little more likely than not. Above that is clear and convincing. And then at trial, the prosecution has to prove its case beyond the reasonable doubt. That means virtually no doubt. But at the hearing phase, it's by a preponderance that the defense has to meet. More questions? Yes, ma'am, in the back.
Yeah, I don't know if you can briefly explain to us what has changed with the military commissions under President Obama, and how do you think this will change the outcome of the trial?
Right. Well, the biggest change, obviously, is the Military Commissions Act of 2009, which the President signed. Major changes are hearsay evidence. In state and military federal court, there are exceptions to the hearsay rule. Previously, in the military commissions, if the government wanted to introduce hearsay evidence, the defense had to prove that it was not reliable. The burden is switched, so now the proponent, the party that wants to put the evidence forward, the hearsay evidence, has a burden of showing that it's reliable. So that burden is shifted. Also now there are greater counsel rights for the detainees accused of committing crimes, of law and war violations. That's the second difference. There are a couple of other differences that escape me right now. Yes?
Back to the hearsay then, what do they have to prove? That it's not hearsay?
No,
that it's reliable?
because remember, there are numerous exceptions to the hearsay rule at trial that you can get evidence in. What they have to show is that the evidence that they want to get in, which is admittedly hearsay, meets a threshold of reliability. And that's the judge's call to make. And that reliability applies equally to the defense and to the prosecution.
Whoever introduces it has to prove it's reliable.
That's correct. And it's up to the judge to determine whether or not that party meets its burden.